Welcome to our channel. Today I will be talking about the legal aspects of investing in a private company. First, a little bit about our law firm and myself. We are a boutique law firm in New York and California. We concentrate on corporate law, intellectual property, and business dispute resolutions. And I'm a corporate lawyer. I'm licensed in New York. I work on corporate governance matters, mergers and acquisitions, including the kind of investment people make or institutional investors make in private companies, and among other things. So the concept of private equity investment is really pretty broad. It generally refers to a situation where one or more investors come together, make short or medium or long-term financial investment in a target company whose securities are not public traded. And the investment could take the form of majority controlling interest in a target company. It could take the form of minority stake. And the form of investment, a source of funds could come from private equity firms, could come from venture capital firms, it could come from families and friends or your competitors or other strategic party that may be interested in your business. Today, we will not be talking much about how a private equity funds work, but briefly. Essentially, investors will provide cash to a private equity fund and will receive the priority return of their capital plus shares of excess profit from the sales of the investment if there's profit. And the fund managers will identify the investment opportunities, monitor and provide directions to the target company and manage the exit of the investment. And in return, they will get a fixed management fee, usually 1 to 2%, and a share of the profit, usually 20% of the profit, which they call carry. So this is just another form of sort of a business legal entity, the rights and obligations among the shareholders, including the managers. So what right may a private equity investor get from the company, ask from the company at least, whether you are a private equity fund or you are an individual. You may be interested in your cousin's next big thing, or a small real estate venture of your colleagues. So the first category of rights are informational rights. The law usually provides not a lot of rights for minority shareholders of a company. So contractual rights are really needed. And the typical package usually include, monthly management reports from the target company, the annual budgets and the business plans of the target company. At least you as a shareholder should be entitled to this kind of information and documents. And you could ask for the audit financial statements and audit accounts and the right to appoint auditors of your own to better understand the financial conditions of the target company. And for that, you need access to books and records as well as the right personnel of the target company. Occasionally, information right also includes you being a non-voting observer of the board. And then, depending on how much money you invest, and among other things, you could also ask for veto powers so that you can veto material changes to the capital structure of the company, which means increase and decrease number of shares or other equity interests of the company, other than, for example, there are carve-outs for these kind of rights. For example, if they need to issue certain amount of stock options to employees, and the stock option plan has been approved already. And then there are change of rights and powers privilege of the shares that you invested, right? And any other change to the capital structure of the company, such as issuance of new shares. liquidation or change of controls of the entity or its material subsidiaries. You definitely at least want to know about these kind of things. And then other rights, the power and including the power to veto material operational decisions of the business, change of the management team, change of the business plan, and major investment or divestitures of the target company, and the commencement of settlement of major litigations, and related party transactions, meaning other shareholders or the management team of the company on the one side and the company on the other side. Any kind of transaction like that, you probably at least want to know, and better yet, have the power to veto this kind of transaction. And you also want to ask for certain personnel power, the power to appoint members of the board of directors. And if you put enough money on the table and the company is desperate for your money, you may want to ask for the majority, the power to appoint the majority of the board of directors. And you also can ask for the power to appoint key executives of the company. A lot of private equity funds, when they make investment in a company, they would ask for the right to appoint the CFO of the company. So that is kind of a nice compromise. You are not, the CFO will not be running the business itself per se, making strategic decisions on the directions and policies of the business, but the CFO is there to know whatever is going on in the company, because everything will eventually flow through the bank. And you may also ask for the right to appoint auditors and of the company, and occasionally counsel of the company, but we really do not see a lot of that. And occasionally people ask for the redemption right. But management founders usually resist this kind of right, which is totally understandable, because that is a right for the shareholders to essentially force the company to buy the shares back from the shareholders at a predetermined price when certain conditions are met. And so that makes the whole equity investment like a debt investment. You have a deadline hanging on your head, and you may have to come up with the cash to pay for that. And of course, occasionally you also have the company having the right to essentially buy the shares back at a predetermined price. And so the flip side of that, as an investor, you may not, you want the company to have that kind of right, because that will cap the return of your investment. So other rights, for example, relate to the future issuance of shares or any similar equity interests of the company. For example, the preemptive rights, that means whenever the company issues new securities, the investor shall have the right of first refusal. So you have no obligation to buy it, but you have the right to buy such a security at the same price. And full retroactive is even better than that. If the company issues shares subsequently at a lower price, the earlier shareholders shall get a price adjustment in the form of additional shares of the company, as if early shareholders paid the same low price as the subsequent shareholder investors of the company. This is a sort of a form of anti-dilution, right? So for example, if you, in a very simplified scenario, you pay $5 per share and you get $20 of the company, and later on the company issues shares at $2.5 per share, then you get, the same number of shares again, as if you, invested in the second one. And so those are kind of sort of affirmative rights. There are also sort of negative rights that you have, and that's obligations of funders essentially. So you want to lock the funders and their shares up, so that the funders will work wholeheartedly for the target company. So there's usually a general prohibition against share transfer by the funders for a certain period of time, usually before the IPO of the company. And there's also the right of first refusal for the investors, meaning if any shareholder, usually the funders find a buyer for their shares, the other shareholders, including the investors, shall have a right of first refusal to buy such shares. So the purpose of that is to prevent funders selling their shares to strangers, and especially at the very unfavorable prices. And then there's also the co-sale right, meaning if the funders have found a good buyer of their shares at good price, then the investors get to sort of tag along and sell proportionately their shares to that buyer for the same price. And there's also this check-along right that is usually reserved for substantial shareholders of the company. What that means is that if that substantial shareholder of the company finds a buyer for the company, as most buyers would prefer to buy the entire equity stake of the entire company, the substantial shareholder gets this contractual right to force other shareholders, at least the funders, to sell their shares at the same price to the buyer of the entire company. That's how you usually manage to have an exit, as the buyer of the entire usually would not just buy a small amount of your equity interest. Usually want to buy an entire company. You also need to have other kind of defensive rights. You would want to the key employees of the company sign employment agreements with the company, and the employment agreement usually will have non-compete covenants, so that after they leave for whatever reason, the company, they could not set up ventures to compete against the company. And also in Asia, you will usually see a lot of performance targets, but it's not very common here in the United States for the executives to sort of stick to certain performance targets, and the failure of them to reach this performance target would, have negative consequences. Sometimes they have to surrender their own shares to the investors. And so you also need to have all employees to sign the intellectual property contribution and confidentiality agreements with the company, so that they will contribute whatever patents, trade secrets, and know-hows to the company. And this is very true for a lot of startup companies and venture, small ventures, because you do not want the company you invest in to have their CEOs and key employees working for different ventures, and you do not really own sort of what through your ownership in the target company, their brain power, their innovation, because that's what you think you paid for. So funders usually could protect themselves with sufferance compensation in case their employment is terminated by the board. And so what I have discussed today in this video should also apply to the circumstances in which a bunch of people come together to set up a new venture, because those kind of restrictions and rights and obligations could also apply to funders versus each other. And what I discussed in the other video on buying and selling a business, could also be relevant here in that you will need to the company to make a lot of representations and warranties to you. In that you as investor of a company need to do due diligence, investigation, the legal aspects and business and financial conditions of the target company. So you may want to refer to that video for further information as to the legal aspects of making an investment in a private company. So this is today's topic. Thank you so much for your time.